Our vision is to help our clients change the world for the better and in ways that are meaningful. And our work is guided by a set of core values that serve as our compass. So these values propel us forward, ensuring that we remain committed to excellence and integrity. A little bit about the services that we provide. So we offer workplace DEI audits and consultations. They also do, I will come in and work with an organization over a longer period of time, really setting up their DEI goals, their action plans, their metrics, etc. We also lead research and evaluation for not-for-profit organizations, public agencies, and businesses, as well as group facilitation services. So the next slide. Yeah, those are just our contact information is there on the slide. Be happy to chat with anyone. But we'll now I'll now introduce Sunira more fully. So Sunira Chaudhri is a litigator and founder of Workley Law. She practices employment law, represents both employers and employees with respect to wrongful terminations, executive compensation issues, constructive dismissal, partnership disputes, and human rights issues. She also represents parties with respect to online work, including the negotiation of contracts for content creation, online consulting, and social media collaborations. She has represented clients at the Ontario Court of Appeal, Divisional Court, Superior Court of Justice, and the Human Rights Tribunal and Human Rights Commission. Sunira attended Osgoode Hall Law School, where she obtained her JD degree. She started her legal career at a leading Toronto litigation boutique firm, followed by serving as partner at one of Canada's leading employment law firms. So we are super, super happy to have you here with us, Sunira.
Thank you, Michelle. Thanks for that introduction. It's great to be here and talk about a very important topic, especially this week, just on passing International Women's Day, of course. So lots to talk about in the DEI sphere, that's for sure.
Wonderful, wonderful. So maybe we'll start with our first question. If there's anything else you wanted to let us know about yourself, and also why you practice this particular area of law.
Yeah, absolutely. So a little bit about me. After becoming partner at a leading Canadian firm that we just mentioned, I actually left after having a child. I was off on what I call an air quotes maternity leave, because I say that because the previous firm I was at had no structure for new parents. And so I went on to start my own firm, which is Workley Law, which we've been growing incrementally since the end of 2021, where, you know, I had a 7-month-old at the time that I launched the firm. So certainly a long road. And of course, DEI initiatives have been at the forefront of my mind through a lot of this. And I'm a labor and employment litigator, as you mentioned, Michelle, and as part of what I do, we represent executive level employees, and we represent corporations, small businesses, medium-sized businesses, mainly with respect to their labor and employment related issues. And the biggest employment issues usually revolve around restructures, terminations, the onboarding of new employees, but sometimes, and it's not all that infrequent, employers are dealing with issues in the workplace that relate to issues of discrimination, of pay equity, of an employee suggesting that the environment is toxic or discriminatory to their group. And so I frequently advise on that, but because I work on both sides, which is on the employee side as well, I'm an advocate for employee rights, of course, when I'm in that arena, and I can certainly understand the kind of weaknesses that employers may have, especially because I've traditionally been aggressive on the other end of it. I know where the holes and where the gaps are a lot of the time in employer policies, where employers are not all that shored up a lot of the time. And so I love labor and employment law in particular because it's very human. It's very challenging in that it's very strategic and can be complex, but you're dealing with real people, and the dynamics of people always change. Even when you're working for a corporation, you're working with people. And so I think understanding the psychology of a lot of where disputes sort of come from and how to resolve them is sort of my maybe my little magic power. But I think in terms of our conversation today, talking about how DEI intersects with the workplace and how employers often have to deal with it, I think it's very timely because it's one of those underrated issues that can sometimes not be addressed at the right time. And most employers are very reactionary, and they only seek help from time to time when an issue is already bubbled up and exploded. And so I think it's great for anybody to take a look at what DEI should mean in the workplace, and how to approach it sort of mindfully to avoid some of those pitfalls down the road.
Awesome. Thank you so much. Thank you so much for that. I think we kind of touched on the second question, how the DEI principles intersect with the law and why it's crucial for employers to understand that intersection. Is there anything else you wanted to add to that, Sunira?
Well, how it intersects in the law, yeah, I gave you a couple of examples. We didn't really talk about the framework, the legislative sort of framework, and I don't want to bore everybody about getting into too far into the law, but I think the major intersection is not one that is notional. It's real. It's real because of the Ontario Human Rights Code. The Ontario Human Rights Code requires that employees are to be free from discrimination in the workplace, and that's on the basis of ancestry, on the basis of gender, race, creed. And so those rights are enshrined in the Human Rights Code. Occupational Health and Safety Act also requires that employees are free to work in a safe working environment, free from bullying and harassment. And so again, the DEI issues, where if individuals sometimes feel as though they are being excluded in the workplace for certain reasons, that might be discriminatory, that might be a lack of DEI training and or awareness in the workplace. And so there are severe, I think, repercussions to employers when culture is not in check. And we have these legislative frameworks that can award damages to employees in the event that discrimination and or bullying or harassment is found when a DEI priority isn't made. And the last thing I'll say is that just in the courts in general, if somebody says they were, just as an example, terminated as a result of going on a parental leave or on the basis of color or on the basis of something that strikes a DEI tone, they can also sue for bad faith damages, punitive damages, aggravated damages. I'm not suggesting that these damages are cumulative, meaning you can get human rights damages and then a whole whack of damages from the Occupational Health and Safety Board, and then from the Ontario Superior Court of Justice. I'm not suggesting it's all cumulative, but what I am suggesting is that there are so many different forums that an employee could raise these issues that it can become, it can balloon very quickly for an employer that doesn't have a DEI mandate in their organization.
Okay, very helpful. And even though you mentioned three different kind of avenues where employees, and I don't even think people realize that there are that many avenues. So maybe we'll jump to, so if an employee, as you were saying, feels that they've been unfairly treated, unfairly terminated, what are some of the first things that they can do to have that rectified?
So if an employee feels that they've been discriminated against, like what's one of the first things?
Yes,
Well,
yes.
yeah. So from an employee perspective, it's interesting. What I tend to find And Michelle, you may find this as well in some of the work that you do, that folks are very reluctant initially to tell their story, and they don't want to make it about that. Because, so as an example, I'll tell a short anecdote. I had a client who, she was a rock star where she was working, making a lot of money. She was terminated shortly after she had to take a family leave period of time, short period of time, because her daughter had to undergo a surgery, a time sensitive surgery. And she was, my client was just working off around the clock as it was. And she knew that if she didn't actually take time off, meaning taking a 1 or 2 month sabbatical, she wouldn't really be there to help her daughter. And her daughter was 3 at the time. So of course, a very vulnerable time. And she was terminated. But instantly, she told me that whole story, and it's quite heartbreaking. I'm a parent. Anybody who's a parent can put themselves in those shoes and think, absolutely, if you're working around the clock, if you're working 12 hours a day, and your child needs to have a surgery, well, you want to have the freedom to be with them 24/7 and not checking your cell phone every 5 minutes to make sure somebody isn't looking for you, of course. And she, despite telling me this whole story and telling me she's sure this is why she was let go, because she was a superstar, she said, and she was almost insulted that I suggested this has to be part of her story when we go to the employer. And she was, aghast. Absolutely not. I don't want to talk about it. I don't want to make my whole story about my time with the employer about that one thing, because that's not what my employment was about. So I'm raising that anecdote because I think what is really tricky about discrimination, what's really tricky about someone feeling singled out and isolated, is that they've almost been trained into silence. And so at the time of a termination, it's very hard to all of a sudden spring up and advocate for yourself and call out the wrongdoing. And so I would say having a full and frank discussion with somebody that you trust, whether it's a counselor, it could be your doctor, it could be your lawyer. And to the extent that it's happening while you're employed, you should be doing that as well. I think people leaning on a counselor, people leaning on their family doctor to talk about some of these things can be very helpful later. But I think sort of documenting some of these things is very important. But I think raising these issues initially with your medical team, to the extent that you are getting counseling, is very helpful. And speaking to a lawyer about what that discrimination was, because you may have a number of options open to you. One might be your lawyer might want to file an HR complaint internally, even though you've been terminated. You might say, this person was discriminated against while they were employed. I want you now to do an HR complaint. Doesn't matter that my guy has been terminated. I want you to do an investigation internally. And some employers now more and more are doing them to make sure they're crossing the T's and dotting the I's, really canvassing and asking yourself if you raise this with anybody internally, because that can be very critical. If you did raise something of concern to a supervisor, even to a colleague, if you've talked about it with HR, if you've, even if it was 2 years ago, anything you can point to that you didn't totally keep your mouth shut about it, can be very helpful to your own credibility, that you're not just simply raising this after the fact. It's unfortunately, it is way easier to raise issues in the workplace after you're terminated, but any evidence you might have to suggest or show that this actually was something you were talking about before the termination really helps to solidify, I think, the existence of it. I think people have to think about how they can objectively present even a little iota of evidence of something that might have happened. It could be an email from your supervisor that was discriminatory, or somebody being upset with you about going on parental leave, or, oh my gosh, you're taking a full 18 months, or something that speaks to the discrimination. And I think that you may want to canvass what forum you may want to pursue your damages potentially as a result of the discrimination. Because I think at the bottom, like the bottom line is, how long is it going to take you to find a similar job, similar level of pay? That is really the question. And if the discrimination or the nature of the termination has really held you back in some way, and it's going to be much harder for you to reemploy, perhaps in your industry, but you don't have, maybe your industry is very niche, you being terminated is really a big reputation killer. That's an example. These are some of the things that factor into how much the discrimination might have really impacted you. And so having a more robust and strategic conversation about what happened, who might know about it, was it documented anywhere, that's really where to start. And if it hasn't been reported anywhere, maybe the first thing you do is you file an HR complaint right after the termination.
Okay. That is super, super helpful, Sunira. Again, like, what do you do? Oftentimes, as you said, people are forced into silence. Sometimes we don't have the energy because we've been so disabused and so hurt by the whole incident that you can't even advocate for yourself. But I appreciate you saying that even after termination or leaving, you still have redress. So that's really helpful information, I think, for everyone to know. Right, so you can speak to a counselor, your medical team, as you said, speak to a lawyer, and start ensuring that things are documented. So Suzanne, I know you had a question in the chat, but I see your hand is up. Please go ahead and mute.
Yes, thank you. Good morning, Michelle, and thank you, Sunira. How are you, Michelle?
I am fabulous. It's been a long time, right?
It has.
So glad you're here.
So I'm wondering, Sunira, you say that the option to pursue a complaint even after the termination is a possibility, but I have heard of situations where folks are asked to sign a sort of NDA release, and the only way that you get any kind of benefit or, I get access to whatever package is through that release. So how, if you have to advise, I work in EDI, so how would you advise someone to proceed with that? The broader question I had in the chat was around, these systems are really all based in, the corporate culture, in systems of oppression, generally speaking. So how do we, one, if we are silenced through that documentation, what would you advise? How do I say, okay, this should be your next step? And how do we attack from a broader perspective? So I'm really interested in your answer. Thanks.
Okay, yeah, so I'll go with your first question first, which is the question with respect to an NDA or a release and as being presented at the time of termination. And that really is the typical situation. So employees terminated, they're offered some package, financial package in exchange for a release. Now, there are two components to most packages, which is, the one would be the Employment Standard Act minimums in Ontario, or the legislated minimums Canada-wide. So as an example, if you've worked somewhere for 5 years, you would be entitled to 5 weeks of notice, 5 weeks of severance. That's statutory, that's 10 weeks. Your employer can't ask you to sign a release for that amount. Anything beyond the statutory minimums, and again, it depends on your years of service. Shorter service employees, the statutory minimums are a bit lower. Beyond those statutory minimums, an employer often would require a signed release to accept that additional gratuitous payment. And so what I advise to employees, especially those that have been a little bit longer service, is I'll say, don't sign the release, because for a lot of reasons, what they've offered you on termination may not be fair. It's going to be a lowball offer more often than not. It's a lowball offer because it's a good business decision and they want you to pay. They want you to accept it. They want you to sign off. And people often feel scared thinking, if I don't sign off today, or by the deadline, it's going to disappear. Well, that's usually never the case. And employers want you to sign that. And so you don't want to sign a release prior to building the evidence you need on your case to make your case what I call sing. And by that, I mean, often what's offered to you in the termination package can be expanded upon. Not always, but most of the time. But sometimes you need the leverage to extract that improvement. And one such way of doing that is by, I've done this for clients. I've done it for a client recently that she was terminated. She was terminated following complaining and lodging a complaint formally with her employer that she was being sexually harassed by a coworker. And despite complaining about it, she even showed her phone with all of her text message conversations with this coworker where he was improperly propositioning her at different times and or getting upset, as an example, if she was sitting next to somebody else rather than him at a company event, and being very jealous and possessive and all inappropriate things. Even after showing that phone conversation to her boss did nothing to separate them. She had to continue to work very closely with this coworker, and she was eventually terminated. And so I raised this example because she did go and advocate for herself, but it went nowhere. And so the first thing I did in my first letter, she did get a package. She didn't accept the package. And we said this was never investigated, and that was illegal. It's illegal that you didn't investigate it. It goes back to what I was talking about at the beginning of the meeting today, which is the requirement under the Occupational Health and Safety Act and the Ontario Human Rights Code that if there is a complaint of harassment, sexual assault, or bullying or violence in the workplace, an employer must investigate. And more often than not, employers are not investigating. And so the moment I wrote that in a letter, they started an investigation. And they did an internal investigation. My gal's outside, but they knew that they couldn't really defend her case without trying to investigate. So we did want to put that onus on them, and something that we can point to, that of course there were really serious allegations made and no investigation had commenced. And so it now has. So I think people cannot rush to sign that release. They absolutely have to think about how strategically they want to pursue their case, if at all, after termination. And again, I think that biggest question is the amount that's been offered to you in the termination package, is it going to bridge you to your next job, or is it just much too low? I mean, in this unpredictable environment, it's often too low. And if you've been subject to discrimination, it could be even harder. So that's a long way of answering my first question. And I think very broadly on the second question with respect to how HR departments are structured, and they are structured often to support the organization and the culture of the organization versus individual employees. I think HR professionals can often feel very conflicted about how to guide and or mentor employees who are facing or navigating very serious challenges. And I think the best way for HR professionals to do that is to be very objective with your organizations. And in my mind, that means reminding organizations of their legal obligations. So it's not about you advocating for a single employee. You're saying, I'm really advocating for us as an organization, which is making sure we're recognizing all of the employee rights here, which is, as an example, if somebody comes to us with a legitimate concern of harassment, of discrimination, of unwanted sexual advances, we are meeting our legal obligations, and the legal obligations are very high, which is we've got to conduct an investigation into these complaints, and we've got to do it very quickly. That's what we've got to do to meet our legal obligations. So I think framing that conversation with the organization in such a way might be helpful, in a way for you to advocate a bit more on behalf of employees who might feel a bit disenfranchised about whether or not HR is there truly to support their interests.
Thank you so much for that.
A great question, Suzanne. And yeah, Sunira, the example you provided of your client, it's also, a bit heartbreaking that we're still seeing these cases of workplace harassment, sexual harassment, and bullying, because that was the impetus for the changes to the Occupational Health and Safety Act back in 2010, maybe. those two cases where women were being harassed at work, you know, they reported their employees, but nothing was done. And in both cases, I believe the women were killed by the harasser. So yeah, it's very serious, as you reminded us, that the workplaces have a legal obligation under the legislation to conduct these investigations, but they're not doing that. Anything you want to share, any insights on why they're not doing the investigations when there are these reports?
I really think it's employers feeling overwhelmed as it is. I can only say that, which is, and they're undertrained. And by undertraining, I think HR professionals in particular do a lot to keep up to date on the law, on evolution within the employment space. But that's not what the entire business is doing. And so businesses are thinking about, well, the bottom line, and well, how expensive would an investigation be? HR professionals, as an example, can conduct the investigation, although many organizations do use, of course, third-party investigators, depending on the sensitivity. And that's often very required, but that can be required because you need your folks to be able to continue their day-to-day work without being sidelined by an investigation that can take weeks, that can require a long report. So I think the requirement to investigate seems very onerous for most employers, that most think, if I ignore this complaint long enough, hopefully the employee's vented and they've now had an opportunity to complain about it, and in a week it's not going to bother them anymore. I think most employers think that that's how they can deal with 90% of the issues. And let's call a spade here. In some cases, that's true. In some cases, something's bothering an employee today and they don't raise it again. They don't raise it again with HR. That doesn't mean it's not something that continues to be a pervasive issue in the workplace. So I think because employers don't see employees ringing the bell over and over and over, they think it's been resolved, and they get this sort of counterpunch at the time of termination, where, like in the case of the anecdote I just shared, an employee says, I raised this with you and I raised it with you again. You didn't investigate it, and now my lawyer is going to come to you about it. Where I bet on the flip side, and this is a big institution that we're suing, and I can talk about it a bit more freely because the case is public, but it's really wild that you see even big institutions failing to conduct these investigations. And I can only think it's because employees raise it once, they see it's not very well received, and they bury it.
That's really, yeah, really disheartening, I must say. But I like what you said, Sunira, that the role of HR professionals in being those advocates, right, internally with the employer. I mean, supporting the employees, but with the employer saying, you know, we need to do this investigation because it's our legal obligation and it's actually protecting us. So being those internal champions around human rights, legal rights, and also diversity, equity, inclusion, huge opportunity, I think, in among many HR teams.
Yeah, just to add to that very quickly, I agree, because, you know, I'm a pretty aggressive litigator in that if I see, which is more often the case than not, where I see that employers have failed to investigate, you know, employment lawyers just pounce all over that. It's much more difficult when you have some thoughtful analyses on the other side, where they say, we knew about it, we looked into it, we investigated it. We received some recommendations, or even if we didn't receive recommendations, we got an investigation done. Based on the findings, we deployed a plan. So we disagree that we let your person go because of it, because we took their complaint seriously the first time. And we made some findings, and the reason your person was let go was for other reasons, not for this reason. And here we have the report, we have all the work, we can show you. It's much more difficult to attack that type of approach versus the approach that is what we see most of the time, which is your person didn't really raise it. They didn't really file a formal complaint with HR. Sure, they might have gone in and had a meeting. Sure, they might have talked to their supervisor, but it wasn't formal. I mean, that's usually what you hear most of the time. You don't hear about that sort of thoughtful execution, which I think serves employers, I think, more readily than burying their heads in the sand.
Right. All right, so if anyone has any other questions, feel free to raise your hand or to drop it in the chat. But not seeing any, I'm going to go to my list of questions. Can you offer any examples of best practices for implementing diversity, equity, and inclusion initiatives while staying compliant with employment laws in Ontario? Anything that you've seen in workplaces that have made you smile or been happy that, yeah, okay, they're doing something positive?
So two things. One thing that happened in my own workplace that made me smile, because, you know, you can talk all you want about best practices, but it's also what you're doing in your own world that matters. And so in mine, I have a lawyer that I work with, and she's just very practical. And she said, before we take too much time and it takes us too long to implement the policies that we need to, she said, you know, I checked out the Ontario Human Rights Code webpage, the Ontario Human Rights Commission page, and they have a poster of employee, you know, that of the rights employee have, as well as their right to investigate. And I can just, she said she just printed that poster and she hung it in our kitchen. She said, they say we should have this up somewhere. So instead of us recreating the wheel, I'm just going to hang it in our kitchen. And she started sending it to all of our clients, which I think is great because a lot of this isn't all that hard. And a lot of this doesn't have to be expensive. And for us to really understand some of the basics around having an open workplace or encouraging of dialogue, talking about the trickier things, because we know these things happen in almost every single workplace, including mine. There are issues that come up and you don't know how to manage them off the bat. So what made me smile was just how simple it is. It's so simple. You can go onto the Ontario Human Rights Commission website. There is a poster of how you can comply. You can iterate on it, you can be creative with it, or you can just hang the dang poster, and that can be a talking point to start from, or something that you iterate off of, or have a quick check-in about it at your next team meeting, saying, see that thing in the kitchen? Well, you know, this is why we put it up. Anybody want to have a dialogue or a conversation? It's a great conversation starter. I think the other best practice, I would say, for teams that are doing annual planning, I think it's a perfect time in annual planning to really consider DEI as being part of your annual policy review. And I've seen some employers, I'm on a board and in our own board governance docs, we're ensuring that those policies for the organization that we're helping to run, as well as in our own governance documents, that there is a lens to DEI that wasn't necessarily part of our review every year. So of course, you look at the mission, the strategic vision of the organization, but I think that including just that one bullet point, like, are our policies DEI compliant? And again, I'm going to echo again, the Ontario Human Rights Code and the Occupational Health and Safety Act. Those are the two places that really enshrine these rights. They are not all that tricky to just supplement into existing policies. And so I think I like seeing organizations building it into their planning so that they're not taking out extra time to do it necessarily. They're turning their minds to it once a year when they're doing their planning for the next year.
Great. Yeah, I think as employers, small business owners, and we also have to, who work in these fields, we also have to model that. So I love the poster, hanging it up, sharing with the employees, and then yeah, being able to discuss it with people on your team as well. Yeah. So next question, what can employers do to prevent discrimination and harassment in their workplaces? And what guidance does employment law offer in terms of the prevention pieces?
Yeah, I think that is a really big question, because management is often the problem, right? I think that we still live in a society where open discrimination is hard to call out. Politically incorrect conversations, let's call them, happen all the time. I think most of us can talk about the last time we were at dinner with colleagues and you hear these stories of CEOs and C-suite executives saying something openly racist, but that they don't think is racist, but it's sort of funny to them, or there's a total culture clash that they might sort of laugh over, but could be very personally offensive to somebody on that team. And so your question about how to reduce it in the workplace, it can only be, it's not, I don't know how much sensitivity training can work some of these impressions out of people. Really, people are who they are. But I think it has to do more so with leadership being a bit more diversified, boards being a bit more diversified, and that those people who are called up to those ranks have the very uncomfortable role of calling it out when they see it, because they're in a position of power to do it. So I think that, and that shouldn't be the case. It really shouldn't. It shouldn't be that a person who's already, has a couple of monkeys on their back, if they're a woman, if they're a person of color, and now having to bat off those preconceived notions about how they may do or how they may fare in an executive role, and then put sort of this tax on them to be the voice for everybody else in the organization who may be disenfranchised. It is unfair, but I think it's necessary, in that if C-suite executives are not called out for what I call casual racism, it won't change. It won't. We will continue to have open dialogue, discussion, and when I say discussion, it could be at an after work drinks event. It could be in a board meeting where you hear this type of stuff, and we've all heard it. I know I'm not the only one. But I will be the first to say, sometimes one becomes too tired to constantly be the advocate and constantly being the one to call out the negativity. And so, or not the negativity, the outward discriminatory conduct. And so I think it's in recruitment. I think HR professionals play a big role there as well. And in terms of advocating for the health of an organization, to the extent that members of management, members of leadership, members of the board do not reflect a diverse group, that's an advocacy piece for sure.
Some research I was doing last year looking at Corporations Canada, the data they tally from corporations who have to report on diversity, and seeing the lack of, there's more women on boards and corporate boards and elite, executive positions. But when you look at other equity deserving groups, that, lag. So Indigenous folks, Black racialized folks, 2S LGBTQ folks, and people with disabilities, still in Canada, we're lagging way, way far behind. in terms of that kind of representation at the executive level. So lots of work still to be done on being able to advocate for more diversity in the C-suite and on the boards as well.
Yeah, it's very tricky because women are making inroads. I mean, women still are certainly not at 50% on boards, but I absolutely agree that the other equity seeking groups, and I mean, it's almost a derogatory term to call us equity seeking, really. I mean, but it is what it is, because we are. We know the stats show that women of color are underpaid in traditional corporate structures, as well as have fewer opportunities for advancement. But I think the flip side of it is when it comes to diversity in the workplace, board placements in the workplace, I think championing diversity too much suggests that the merit-based element is gone, and we're simply looking to check a box that the person in that position has the right skin tone, which is absolutely not true, and it can undermine the credibility of the candidate, especially when diversity becomes too much or too pronounced a priority. I've traditionally done a lot of media, and I can tell you that some of the comments that come in, especially when I was employed at my last firm, was that I was a diversity hire. I'm only on the radio because I'm a diversity hire. And it had nothing to do with my own credentials, had nothing to do with the law school I went to or how hard I work. Not at all. It was, you must be here. So, because your firm is just checking a box. And that is still, it remains a prevalent stigma, I think, for people of color, women, equity seeking groups, when they get to leadership positions, that it comes with a hint of doubt as to whether or not they can really take on the role. And again, then maybe that's the third monkey on their back when taking them on. But I think it's this generation, probably the next generation, that's really going to bear the brunt of it before that sort of narrative begins to die down.
Yeah, and of course, there's so much backlash now around DEI. We're seeing, especially in the US, right, where people are
In the
calling
legal
out.
profession too. In the
Yeah,
legal profession too, yeah.
right, right. All right. So how about another question? Again, if anyone has one, please feel free to unmute or drop something in the chat. So we'll be happy to answer your questions. And I'll ask, how can employers accommodate diverse needs, including those related to disabilities, religious beliefs, cultural backgrounds in workplaces as well?
Yeah, I think disabilities, let's start with that one. All employers in Ontario are required to be compliant with a piece of legislation called the AODA. So it's an acronym that I believe it's Accessibility for Ontarians with Disability Act, something like this. Sorry, I'm just talking off the top of my head. But that act requires employers to take make reasonable accommodations. And I think employers have leapfrogged, ahead pretty quickly with COVID and making remote and hybrid work arrangements that much more accessible. So I think employees with disabilities are getting, in some ways, some more accommodation that they didn't in the past, but most employers don't have a metric. I think it's really only the very big ones. We're talking big banks, those with thousands of employees that have a robust policy, because you have to ensure, of course, as well, that those with disabilities, those that might require other accommodations. You pointed to one, Michelle, like religious accommodations as an example. There might be other medical accommodations. So someone might not be disabled from walking into work, but there might be medical accommodations that they require in order to do their role. And some employers will say they're diverse, they're diversity seeking employers, they will make requests with respect to accommodations employees might have if they choose to identify that they are a person with a disability. So I think there is a very mindful way of going about it. But the fact of the matter is that many employers, many employees are reluctant to seek employment at mid-size and small range companies, in my experience, because the protocols just are not in place to adequately really support or accommodate disabilities or accommodate religious, rights and or beliefs. So as an example, there are some bigger organizations that might have a prayer room that might be able to help accommodate some religious aspects on site, might have separate washing areas or a separate kitchen for folks depending on the religious needs. Now, that may not be the case, of course, with smaller institutions. So I think what I tend to see is that those that require more stricter adherence to certain accommodation requests might gravitate more towards those larger institutions. But I would say that in seeking to provide accommodations to those, consider your hiring process. I think that's the first step, because I think really having a cogent conversation at that time, and if you're really open and willing to provide those accommodations, that might be a very good time to explore the nature of the accommodations required in a really more honest way with the individual, and talking about what you can and cannot do. Whereas I think most employers just sort of avoid that conversation as a whole, hoping it doesn't come up, and then they're not adequately prepared to meet those accommodation requests later on.
Yeah, I didn't realize that. Yeah, I guess it makes sense that larger workplaces, persons who have particular needs may gravitate towards those kinds of workplaces because they can be better accommodated. So yeah, helpful information when thinking about accommodation. Right?
Sure.
So I think we have just a few minutes left. So a future trend challenge, kind of looking into the future, into your crystal ball or whatever, Sunira. Looking ahead, what are some trends or challenges that you see coming down the pipeline in terms of the intersection of DEI and employment law that we should all, whether it's employees or employers, be looking out for?
It's a great question, and it's the day after the Oscars, and I love the Oscars. And I'm mentioning the Oscars because I had such an interesting case that came to me a few years ago after, I think it was Patricia Arquette. She goes up, she wins an Oscar, and she talks about pay equity and how women actors get paid so much less. And I think this was just before Me Too. But that was really a galvanizing moment, I think, the year before Me Too, for actresses to come out and say, it's about time we get paid the same. And so I had a client who saw that inspiring speech, and the next day, she worked at a big bank. The next day, she sort of she had access to the payroll records of the bank. And she accessed them improperly because she wanted to know if she was getting paid the same as her colleagues or not. And she found out she wasn't. She found out she was getting vastly underpaid, 30% underpaid, by a guy that she hired. He was a manager too, but she hired him and he was getting paid 30% more than she was. So she was bent out of shape, emails her boss, says, what gives? I found out that this happened. And she gets fired for cause, for accessing records she shouldn't have. It's a very weird case because she shouldn't have done that. But it's just funny, in retrospect. I mean, it all worked out well and she got a great package. And I suggested they didn't have cause, although, it was a bit tenuous. But what she had on them was a much bigger story. which is the trend, I think, that even though that was probably a speech made 6 or 7 years ago now, um, it's still the biggest dirty little secret, I think, which is the lack of pay equity across the board. And most employers live in a black box when it comes to compensation. Employees are taught not to discuss compensation because, of course, there's power in numbers and all that jazz. And people are very private about what they make in general. But Salesforce was on 60 Minutes. The founder of Salesforce was on 60 Minutes a few years ago. And he said that the company conducted a pay equity review and found that, of course, shocker, women were underpaid in the organization. And I think it cost them tens of millions of dollars to correct it, to actually right size, right, individuals, because there was so much discretion, right, that managers were using. And obviously, a lot of this discretion was favoring males over females that were doing the same jobs. But what was interesting was that one shot wasn't enough. The Salesforce founder said, we did it again a year later. And while the delta wasn't as big, it was still pretty astonishing, still pretty big. So the same dynamics were still at play. Obviously, you still have the same managers. You still have the same folks that are probably their bias is favoring one, type of person over the other. And so I think the trend this year, we've seen some changes in legislation about employers having to post ranges for roles. I've personally started doing it because I think to be fair and equitable to individuals, that's what you probably should do. But that's going to be a big shift because I think people are going to be asking a lot more about what their counterparts are being made. When you're asked what your salary expectations are, your salary shouldn't be, I think, specific to you. It should be about the role and whether or not you meet the specifications of the role and what the role pays. And so I think a lot of that discretion is going to go by the wayside. And I think we're going to see that even really large institutions have been employing this very ad hoc approach to compensation that could really, really backfire for a lot of big institutions for continuing to conduct themselves in that way.
That was such a great response. I wasn't sure what you would say, but that was amazing. Yeah, the pay equity, that pay transparency that has been missing for too long. We'll maybe finally start making some inroads into that. And then people, yeah, so that employers are upfront about the pay and that everyone who's hired into that role, for example, will be paid the same going forward like that.
Yeah,
That
like
would
think
be a
about
huge win, right?
Yeah, think about it, Michelle. Like, I mean, if you know that it's a problem within your organization, and it's usually like a horse that's taken off on you, it's not something you can control, especially if you have, let's say you have even over 40 employees, and you can see internally, you look and you see, oh, these folks are up here and these folks are down here, and there's at least a few people down here that should be up here, and there's at least a few people up here that should be down here, right? When you see that and you're like, how the hell do I fix this problem that I made? Well, that's exactly the time you probably want somebody helping you behind the scenes, maybe applying some DEI principles to right the ship in a lot of ways and doing those compensation adjustments, or at the very least have a principled way of going about your onboarding and going about your compensation increases and going about your bonuses in the future, so that maybe this is not going to be something that will correct itself in 6 months or a year or 2 years, but you're going to get there. This delta is going to begin to come down, and you will at least have a track record of showing that you've been working on it.
So awesome. And yeah, it's the example of Salesforce. Yeah, they always tell people DEI is a long game. It's not a quick fix. So Salesforce said, we did this, we thought we were going to get great results, and after a year, we revisited, and they were probably surprised that although they had made some progress, they hadn't made as much as maybe they had intended to. So that
Yeah, you would think they would give themselves like, a big party, like we did it. And of course, this is it's a long and it can be an expensive process, but when you get to being that big of an institution, a corporation, it's incumbent on you as an organization, as a leader, especially, I mean, everybody and their mother has heard of Salesforce. If you hear that your half of your population, half of the people that work for you are being underpaid because of some kind of internal stigma or bias that's being propagated, that's a problem.
Absolutely, absolutely. And then to take action quickly to fix it, right? The other part of it, yeah.
Absolutely. Effort's all you can do, especially if you've been around for a long time and you have been employing some, shoot from the hip compensation strategies. I think compensation has to be a thoughtful process, especially when you're getting beyond, even 10 employees. And how are you're thinking about the market, you are thinking about the candidate and getting the right candidates at first. But once you become a real going concern with a culture, that setting of the measuring stick, and I think implementing that discipline, the mission, the mandate into all things. And what is more important than compensation when it comes to work? I mean, few things are more important than compensation. I think that's going to be the trend. And I think we're going to see a couple of blowups along the way when some of this information begins to become, I think, public fodder. And what employers should be doing now is hoping to work against that and to minimize the impact for their groups.
Sunira, thank you so very much. This conversation has been super, super helpful. I hope everyone else has also enjoyed the conversation. You shared so much insight, so many nuggets. Can't thank you enough, everyone. Thank you so much for joining us here today. Yeah, you need to, and how can people reach you if they want to follow up with you? I don't think we said that.
Oh, I will leave my email. I'm going to just type it right here in the chat. I'm Sunira@workleylaw.com. Workley, yeah, I sort of made up the name, but work and then lylaw.com. You can look me up. I really enjoyed this conversation. I didn't know where we were going to go. I didn't even think I would talk about the Oscars, but I did. Really
Right.
great. I loved the conversation. I think we all nerd out for things workplace oriented. So, whenever I have an opportunity to have a conversation like this, I always jump at it. So I appreciate the time. I really do. And all the thoughtful questions.
Okay, great. So thanks everyone again for joining us today. We'll be continuing on a number of webinars. Next month, we're looking at data analytics and DEI. So how can we tell stories of the data that we collect or should be collecting? It should be another great conversation. So I hope you'll join us at our next session as well. Thanks again.
Bye, everyone.
Bye. Take good care.